Thank you, Virginia. I am delighted to be here. After that introduction, I'm not sure if I'm not the devil's advocate in this organization. What an illustrious group that was assembled. I'm just pleased to be part of it. General Early and I've just recounted some of the concerns that I had when I was Attorney General, as he has been. Also, it's good to be with Anthony Graves, who can speak with more particularity on the issues that we're talking about generally. I'm also honored to be part of the Aiken Gump organization here. Nikki, thank you for what you've done, what your great law firm has done. I feel very much persuaded that had Bob Strauss lived, he would have already solved this problem, and we would be on to another issue. Those of you not familiar with Bob Strauss, I might add, was from Texas, but he did spend a lot of time in Washington and was one of those who brought people together. This is an organization, the Constitution Project, has brought people together who come from diverse views on the death penalty. We have those who are strong advocates, which I had been, and also those who have strongly opposed it. In order to bring those groups together, we are today announcing the product of our work, Irreversible Error. It's a program in which it doesn't really bring out any moral judgment so much as points out things that need to be done and must be done in order to see that the death penalty, if administered, will be done fairly. Wrongful convictions, we're familiar with. This committee's been working for more than a decade, and now the result of that effort is before you today. We've had members of the committee that are judges. They've overseen criminal trials that included the death penalty, both in state and federal courts. They've had members who were prosecutors who have imposed the death sentence, carried out execution. We have members of a committee who were investigating the capital crimes for our enforcement agencies, others who've defended capital crimes. Some of our members who also have suffered as a result of those crimes and the victims of those brutal crimes themselves. As governor of Texas, I oversaw 19 executions, and I can tell you that there's no more gut-wrenching experience for, at least for me as governor, than to preside or have a part to play in those executions. I was very involved in it because, having previously been an attorney general and a lawyer, having also defended one person who was accused of capital murder, I was intimately familiar with the details of those prosecutions and also the frailties. I had been convinced that we were doing a good job and we were protecting the defendant, affording them all of the protections of the Constitution and the laws of our state. Over the years since that time, I am not so certain that we're doing a good job of that at all. This past week, the death penalty was thrust back into... Is it you hear too much or can't hear enough? Sometimes that's better. This past week, the death penalty was thrust back into the public debate as a attempted execution of Clayton Lockett in Oklahoma resulted in what has been called a botched execution. I don't think botched is the right word. I think that's one of the worst political cop-out words I've ever heard. That was gruesome, it was torture, it was inhumane, and it was wrong to the core. The fact that it broke down in Oklahoma, only to be rejoiced on the part of our Texas governor, in which he said that we'd never had that problem. That I hope is true, but I hope it's not just a hope, because we never know until it's too late, and this procedure has not been well vetted. My fellow committee members are very concerned, deeply concerned over this process and the flaws that are within it. And since I've left the governor's mansion, I have seen that there is an abundance of unfairness and accuracy in which we go about this process. Texas, though, has made some reforms. We're doing a better job than we did in the past in giving support to the defense in rural parts of our state. By and large, though, we're seeing continuation of procedures across the nation that are outdated policies. They have not done anything to support the fairness of this procedure. The forensic problems that we have, I guess no greater example of how flawed it is the Houston, Texas Police Department ran the forensic testing there. We didn't have anything wrong with it except we had leaks in the ceiling that contaminated the samples. We had people who were not qualified to do the testing, and they were also others who testified. You couldn't paint a picture of a worse situation than what we had there in Houston. Corrections have been made, but we failed to take one rule into account. We've known about those problems for years. And even after we acknowledged the problems, it's taken more than 4 years to take action to see that they're corrected. I remind people constantly that we fought and won World War II in less than 4 years. Seemingly, we could cure that rather simple problem in less time. Even our National Academy of Sciences have weighed in on the fact that our forensics at criminal justice level are flawed, and they are suggesting that action be taken. It's good to think about one statistic. Over 50% of the first 225 wrongful convictions that were overturned by DNA testing, over 50% of them, those convictions were based on science, forensic science. That was what it was called then. It's called junk science now. Supreme Court has declared, for instance, those people who are intellectually disabled from being given the death penalty. Today in Texas, we had the horrific circumstance, combination of events in which the state administered the test for IQ. The state administered their own test, and the defendant failed it by 7 or 8 points, only to have the prosecutor in a rural court stand up and inform the court that, oh, Judge, you know those people don't test well. Can you imagine in the 21st century we have that sort of comment going on in a criminal court in which the life of a person is being tested? The problem with that was we didn't get any judicial review because the federal courts have constrained our judicial review such that we don't get the use of the most important writ we have, the writ of habeas corpus. This particular defendant had already used his writ. The fact that a lawyer may have abused the writ should not be a factor that condemns the person to whom it's to be used for protection from using it. That needs to be changed. Last week we saw the President of the United States appropriately speak to the need for a review of the death penalty in our country. I think that it could be nothing could be more timely than the issuance of our report today. And I think that Jenny and others have told me that that report will be afforded to the Attorney General, Eric Holder, and it is a good beginning, if not a beginning and an end, to the review that needs to be done to make significant changes in our criminal justice system affecting the death penalty. And for that reason, I'm very pleased to share this role with General Early as co-chair, and also to turn this podium over to him because he speaks more definitively to the issues because of his experience in Virginia, which is, I guess, second only to Texas and probably would exceed Texas if they just had more in the line of execution. But General Early speaks fluently on these issues, and he, too, was one of the leaders that brought about this remarkable study that's being given to you today. Thank you, General.